People v. Mosley. And we are delighted to be joined by our colleague from the Second Department, the Honorable Betsy Barros.
Good afternoon, Your Honors. May it please the Court, Thomas Leith for Mr. Farod Mosley. Detective Kilbourne should not have been permitted to offer his opinion to the jury that it was Mr. Mosley depicted in the low-quality, blurry video that was shown to the jury in this case and was the crucial piece of
And what is
evidence.
the reason why? Is it because he did not know him at the time of the commission of the crime?
There are various reasons, Your Honor. First, the trial court applied the wrong legal standard regarding lay opinion testimony. In our view, the court only required a bare familiarity with the defendant in this case.
How much do you need? How much familiarity is enough familiarity?
Well, according to this court's case law, it should be something connected close to in time to, first of all, close in time to the events depicted in the photo or the video. There should be certainly more than what we saw here. There should be testimony regarding, the quality of the interactions, how numerous they were. Here we have an officer who could only recall one specific time that he spoke to Mr. Mosley. And this was after...
Can I ask you on that specifically? The appellate division dissent, and it sounds like you agree, said that they only met once. Can you tell me where in the record that's apparent? Because I couldn't make it out.
I believe it's in the voir dire, is only able to specifically recall one time that he actually met. Now, there may have been other times. There was only one time that he could recall meeting with Mr. Mosley. And let's keep in mind the context of this, Your Honor. That shouldn't be surprising. Mr. Mosley had been arrested. He had been incarcerated. And that was the first time that Detective Kilbourne met him. And so presumably and he was never released on bond, so presumably he brought him from jail to the station or somewhere where he could interview him.
What do you do about the constraints on cross that I think existed because of concerns about revealing too much that might tell the jury about the circumstances in which they had interacted?
Well, the cross-examination problem is a big one, Your Honor, and especially when it concerns law enforcement, and you saw that play out in this case.
Well, what's the solution to it? Is the solution that a law enforcement officer is somehow disqualified from testifying? I'm just trying to understand how you would deal with it.
First of all, it's a reason to be very skeptical of allowing this kind of testimony because there is this difficult problem to get around, surely, and the court perhaps a little ham-fistedly tried to do that in this case, and we saw the problems. The defense counsel was unable to interrogate on cross anything about the nature of the...
That seemed to be a decision that he made, because he didn't even ask a question to clarify how many times, what's the total time that you spent together, from what angles did you view him. A number of questions could have been asked, I think, that would not have run afoul of, having the danger of introducing the jury to the fact that he knew him from prior arrests. Like, the record here is pretty bare, but the defense attorney could have asked a lot more questions and didn't. Do you disagree with that?
I don't disagree with that. Surely there were more questions that the defense attorney could have asked, but some things he could not have asked were, for example, where did you meet with this defendant?
Right.
Did you meet him on the street? Because he's going to open the door to a lot of extremely prejudicial information, and if the answer is no, I didn't meet him on the street, there's a very clear implication that it was a part of this detective's investigation. So I think that the problems with cross, Your Honor, it doesn't automatically disqualify law enforcement from testifying in these situations, but it is something that the trial court needs to consider very carefully, especially when it considers the amount of prejudice that might result from allowing this type of opinion testimony, which the trial court did not do in this case.
So are you proposing some sort of bright line or categorical rule that says arresting officers can't testify in this type of situation? Or are you advocating for anything other than just making sure that there's a foundation for the admission of the evidence? Is there a categorical rule that you think should be applied?
I don't necessarily think there needs to be a categorical rule. I do think, however, that allowing post-arrest familiarity by a law enforcement officer to testify as to their opinion whether or not something like a video is the defendant should be viewed extremely skeptically, in part because of the cross-examination limitations that would occur.
Because I'm going to refer to your
Please.
question that you asked just a moment ago. It seems like in this case, everyone is sort of really taking great pains to avoid exposing the arrest. And I think you've heard questions from across the panel about things that could have been asked that weren't asked. And if you were to ask me about that, it seems the motivation behind that was not to let the horse out of the barn. Who bears the responsibility, assuming that that's correct, who bears the responsibility for failing to develop the record adequately with respect to the officer's familiarity with the defendant?
I think that perhaps multiple parties bear some responsibility here. I think that the defense counsel was put in a very difficult situation about how to develop at least...
I think everyone was, don't you? It seems as if everyone took the judge very seriously and did not want to let this out. And they were very limited in their questioning on this very issue.
And I think it's a reason to be particularly skeptical of this type of testimony, Your Honor, especially when you consider how little value it was really providing to the jury, which are some of the other...
And why is that? Wasn't this really the only evidence? If in fact the officer had some experience with the defendant and the video was poor quality, wouldn't the officer at least provide some better basis?
Potentially, Your Honor, but here's the problem. This officer, first of all, his familiarity was overstated, I believe, by the Fourth Department in its decision, as outlined by the dissent, I think, very well. But the problem here is that given this officer's familiarity, whatever it is, he needed to be able to connect that familiarity to some observable thing that he could articulate, that he can point to in, say, a video that the jury can then use in its independent determination of who it is in that video. And that never happened here.
Can I ask you to go back to Judge Canataro's question about, who has responsibility to develop the record? Is the answer to that the same in the context of cross as opposed to voir dire, or do the people have more of a burden in voir dire to establish the officer's familiarity with the defendant and lay a foundation for introducing his testimony?
Well, I think that clearly the defense counsel's not as constrained in the voir dire about their cross-examination about developing the officer's familiarity because it's not in front of the jury.
Sure.
And the opposite is true, of course, once he is. And I think that it's the people's burden, first of all, to establish this familiarity in the first instance, and that would occur. We argue that this should occur during the voir dire, first of all, which is, we think, is another problem with the way that this happened here, is that that's the moment when the foundation needs to be laid. Now, the Fourth Department talked a little bit, the majority talked about some reasons to think that a foundation was laid, but this was already after he was testifying in front of the jury, and in fact, the judge had already allowed this identification to occur. He only afterwards says, here was the basis of my recognition. Here's why I can tell you that I think it's the guy. But this happened already after the identification would be made. There was no testimony like this whatsoever during the actual foundational part during the voir dire. And this is something that we think was an error made by the lower court, that it should occur in that earlier period. And the other...
What do you propose as a test, a way to approach these kinds of cases? They're very commonplace now. They weren't before, and we don't have a lot of jurisprudence on this issue, in as much as it involves a non-recipient witness. What do you propose as a way to approach these kinds of cases? This is not the best example of how it should be approached. I think everybody would agree on that. What do you think should be done? Should there be a request for like, a sort of like a Rodriguez hearing, something where you establish the familiarity and have a full-fledged hearing to determine whether or not this evidence should be admissible?
Something like that, Your Honor. So I think, first of all, there should be some sort of jury out, voir dire type hearing. And in that hearing, the first thing that should be established is the familiarity aspect.
Didn't that happen here?
That's the only thing that happened, but yes, it did happen. There was a jury out hearing,
Right.
and there was testimony at the jury out hearing about familiarity. Now, we say it was inadequate, but that's just the first step. And to get to what we would consider a test, the next part is there has to be some nexus between that familiarity. Like, how does he recognize this person in that video? And there has to be some observable thing in the video itself that he can point to that will actually be useful for the jury to see, because it doesn't matter if the video looks like TV static, Mr. Mosley's own mother wouldn't be able to identify him. So there has to be something in that video that the witness can point to that the jury can then use constructively to make an identification one way or the other. So that's the second step. The third step is whatever that identifiable characteristic is, it has to be something that the jury could not have seen on its own otherwise. So for example, in this case, although this didn't happen in the voir dire, this happened afterwards during the jury testimony, the witness says, well, I'm basing this on the shape of his nose and his build. Well, the shape of his nose and his build are something that the jury can very well see. They're looking at this defendant for 3 days during trial, and I would submit that they have every bit as good a recognition of what this guy's nose looks like and his build looks like as that officer who met him maybe once or a few times.
Can you see the shape of his nose on this video?
You cannot whatsoever. If you didn't know humans had noses, you still wouldn't know after watching this video.
I have to tell you, so I don't know what this means, but I think if you pause the video when his face is in the frame, it's very pixelated. I can't see the shape of anything. But what I can see is a lighter colored pixel where his nose might be. Does that mean anything? Is there a discoloration issue with this defendant's nose? Is his nose lighter than the rest of him?
Not that was in the record, Judge. And certainly at no point did the witness say, you know, look at a video and say, here, you see the nose here? This is why I knew it was him. There's nothing of that nature at all. And even seeing a person's nose or face at all is almost a generous interpretation of how that video
What about
looks.
his statements that he framed in and out on that video, suggesting that he did spend more time connecting whatever was his recollection of the appearance, right, based on his interactions of the defendant, and the figure in the video?
If he zoomed in and out in the video in some way, and I have zoomed in and out of that video, he never explained to anyone, to the judge in the foundational hearing, how that zooming in and out could have possibly elicited an identification.
So you're saying it could have been enough, but in this case, because there wasn't the actual connection, it wasn't enough. Am I hearing that right?
Well, perhaps in another case it could have been enough. I don't think it's irrelevant if he could zoom in and then, oh yes, there's something in the video that I recognize. That didn't happen here. And there was never any explanation as to how that zooming aided his identification in any way.
Well, the jury wanted to zoom in and out with a magnifying glass, right? And they were not permitted to obviously have a magnifying glass for the proceeding. It sounds like they were also trying to do what the officer may have testified about.
They were, Your Honor. I do believe that the jury had the opportunity to Zoom. Now, whether or not they Zoomed in the same way as the witness is impossible to tell. I don't know that there's multiple, it seems there's only one way to Zoom on this video. So clearly the jury, I mean, and there's no doubt that this was extremely important evidence. In fact, it was really the only evidence. And there's no doubt that Detective Kilbourne's testimony, opinion testimony about whether or not the video depicted the defendant was very important. They asked, can we base our verdict on one witness's testimony? They meant Detective Kilbourne. And that they asked about the magnifying glass. And they wanted to read back Detective Kilbourne's testimony. They wanted to watch the video again, all of which just goes to show the importance of this video and how there's no doubt that the improper nature of this testimony was prejudicial to Mr. Mosley.
How does this tie into the judge's limiting instruction and final instruction? Was there an instruction regarding the opinion evidence that was offered here?
There was not.
And is that similar to the ID? Is that sufficient? Is the identification charge sufficient to cover this scenario?
In this instance, Your Honor, and you asked what we thought would be the procedure for a judge, we think that they should, of course, give a limiting instruction informing the jury that this is merely, this is an opinion that can be rejected or accepted by the jury.
And was that requested?
That was not requested.
And so why would we take issue with the failure to give it at this juncture?
I think, well, maybe not as an independent basis to reverse, Your Honor, but I certainly, I don't think that there was no limiting instruction that might bolster the people's case because it just didn't exist, whether or not, and I think it's just another brick in the wall, I suppose you might say, as to why we believe that this was an impermissible conviction.
But just to clarify, are you asking what, keeping in mind what Judge Halligan has just said, that nevertheless moving forward, that this is a best practice or that courts should do this regardless of whether or not there's a request?
Yes, yes, and at the time, and I think there is cases that say it might be best practices at the time when the testimony is given for the judge to make a simultaneous admonishment to take this testimony for what it is, which is opinion testimony.
Thank you.
Good afternoon, Your Honors. Brad Osler for the people. My reading of this case, and I think our brief lays this out, is that there's two distinct questions. There's a question of law and a mixed question. The question of law is perhaps going to be engender less debate here, but I think our position is that a post-crime familiarity by a non-percipient witness is a valid basis on which for that witness to base a lay opinion that somebody depicted is the defendant. We lay this out in our brief. I think the same risks that are associated with somebody who maybe grew up with a defendant and then identifies them in a video.
Would you agree it has to be roughly contemporary, over here, roughly contemporaneous? In other words, if the crime is 10 years ago and I see I have a familiarity, from last month.
That would be a better scenario, or an ideal one, I suppose. I don't think it would be appropriate for there to be a bright line rule setting out a time limit. And I say that because, and this is an example that I think would create a real issue with that, with a strict rule, but a parent, somebody who maybe spent more time with a child than anybody else.
Do you agree that rough contemporaneousness is something that would bear on whether it's appropriate?
Yes, I think it has to be. But I think it's also something for the trial court as sort of the gatekeeper for evidence that's not going to be unduly prejudicial. It's the trial court's ability. They're in the unique position to make that determination. But certainly a temporal aspect is going to be part of the overall consideration.
Why is that actually necessary if there's not any physical change? Perhaps, I think you said 10 years, if I'm not mistaken, Judge Halligan. So if it's a decade, perhaps there is some physical change. But
And that's one of the other
if there's
factors.
none, if there is actually no physical change, why does it matter? temporally?
Well, and that's why I don't think it's the only factor to be considered. It is certainly going to be one, along with, anything else we could think of that might play into whether an identification is going to be, credible or more of just a guess that's not going to be supported by some level of actual familiarity or for that witness to be in a position to have some basis to assist the
But
jury in
what about
making-
your adversary's point that a foundation was stated, but then it wasn't connected to the actual video? So when he says he's got some kind of distinct feature about his nose, and then he doesn't show the jury what he's talking about the nose, is the jury supposed to do that analysis on its own?
So this is where, Your Honor, I would say we've moved into the mixed question in terms of what happened in this case. Now, I think, readily admit that I also cannot see anything in the video that suggests a shape of a nose, and I've also seen that pixel that seems a little lighter than the surrounding ones, but there's no way for us to tell a shape of a nose. I think I would very much agree on that point. However, the officer didn't say only the shape of the nose. He really seemed to focus more, both on voir dire and then his ultimate testimony in front of the jury, with body type or build and his gait. And I think the video does show a body type or build, and it does show a gait. There
Did he
is,
elaborate on that at all? I mean, build is, yeah, everyone's got a build, but tell us what it is about this build that's distinctive.
he did not elaborate. I think there might have been a mention of like a slender build, something along those lines.
Are you sure about that? Because I had a hard time finding any elaboration.
That may have been in cross, I'm not going to promise that it's in there. I thought there was a brief mention, but by and large, he does not elaborate for the jury. I don't know if that's necessary for him to.
Can I ask something here on that? It seems to me, and this struck me when I read your brief, that the justification for allowing this officer to come in and do this was that the video was blurry. And it's really the only proof in this case. So I'm struggling with, how do we factor in that you have the sole evidence really linking this defendant to this crime, which is too blurry, and you bring in a police officer to say, yes, that's the guy, and that's really the only evidence you have? How do you factor that into what foundation you have to lay to allow that testimony?
I think the way that the trial court looked at it is essentially the way I would suggest is the appropriate way, which is going to be a combination of, does the officer have some familiarity, and to what degrees did that familiarity develop, what kind of detail, and that is something that is mentioned in the jury instructions in terms of what the jury should consider about the officer's familiarity and ability to identify the defendant. And then coupling that with, I think in this case we have what I would describe as a video that's of somewhat moderate quality. It's pixelated enough that we're not going to see somebody's face necessarily and say, yep, that's definitely.
So the idea is helpful in that
Oh,
case, but
absolutely.
it just seems, I don't know, this is way before your time, but the Guys and Dolls movie where Big Julie rolls the blank dice, but he remembers where the spots were. And he wins all the time.
Well, so
He loses when he bets $1, just to show that the game's fair.
So what I would say in response to that, Your Honor, is that it is the province of the jury to determine whether or not they actually find the testimony to be credible. Now, I think the court here, in a somewhat prescient manner, did, I think what would be an appropriate process, also sort of in line with Purdue from a month or so ago, where we have a pause in the trial to determine if this testimony should be permitted. So we have the voir dire testimony, the court decides it's appropriate, and then it's up for the people questioning the detective in this case to provide enough of a basis for the jury to believe him, to actually find that's the case. And the jury, any lay juror, is going to look at the video and look at the detective's testimony and say, do I actually believe that he has an ability to identify the defendant in the video, despite the quality and zooming issues and the pixelated nature of it at times.
But don't you think a police witness, a law enforcement witness would carry more weight with the jury than a lay witness looking at the same evidence?
I suppose I would have to recognize that that is a reality, despite the jury charge that instructs the jury not to give them either the benefit of the doubt or to otherwise hold it against them.
Isn't that made more challenging by the constraints on cross as well? What do we make of that?
I disagree that the constraints on cross are so problematic here, such that they're...
Why are they not? In another circumstance, if there was an interaction, there would be an opportunity for a fairly more extensive exchange, even if you could have asked another question or two in this case. So how does that weigh in our analysis?
I think the types of questions that could have been asked here by presumably defense counsel on
Like,
cross.
where did you see him?
Well, I think it would be more hitting at the potential bias of the police officer, sort of the argument of everything is a nail if you're a hammer. If the main criticism, I suppose, of the officer's identification here is that he's doing it because he wants to help solve a crime, and he's not really concerned about who he identifies. He just wants to help his fellow officers out and solve this case. That type of questioning is going to be enough to at least plant the seed in the minds of the jurors. Let's be skeptical here about an identification that's not made by some
I'm just
defendant.
trying to understand, is it your view that this can weigh in the analysis, those constraints, or that it's not relevant, or it has some weight but not dispositive?
It may have, there could be scenarios certainly where the inability to question maybe the exact circumstances where the familiarity developed is going to be problematic. I don't think there's anything in this case where that would have prohibited defense counsel from saying, let's talk about when you met him. Were you in a room? Was it well lit? How close were you? How long were you in the room with him? None of that necessarily speaks to, oh, you were questioning him because he was arrested for something. It's just going into the same type, the same way we might cross-examine a witness who's developed a familiarity in any other scenario.
Do you agree that the record only reveals one interaction between the two of them?
I don't agree with that.
So you think, where would we look? Because the appellate division dissent thought it was one, right?
So I disagree with the dissent respectfully, but in both his voir dire and, well, let's start with the voir dire. He mentions that he's involved in 3 investigations and that, I believe his language is numerous times, he had sat with the defendant in the same room, walked with him, viewed photos. Moving on to his testimony in front of the jury, he says that he, I believe, met with the defendant on a couple of occasions.
But that could have been in one day, presumably, we don't know.
That is true. It could have been perhaps a couple meetings in the course of one day.
So is the foundation your responsibility to establish the familiarity, i.e., it was over a course of 1.5 years, and I had many occasions to speak with him, to walk with him. Where's the burden here?
Oh, I think it's with us, Your Honor. It ends up being in 2 steps, I think, as we had here. We have to first make sure that the trial court understands there's an adequate basis, just sort of from the broader...
So what is the basis? You did say he worked on this homicide, in the voir dire, he worked on this homicide, he was involved in the lineup, so he walked him to the room, he was involved in getting a confession from him, or he canvassed and saw him numerous times on the street. None of that, it's just, very general.
It
right?
could have been more specific, certainly, but the notes that I have from the voir dire are 3 investigations taking place over the course of 18 months, numerous times sitting with him, walking with him, and viewing photos. The first meeting of which was in January of 2016, which is about 7 months after the shooting in question here.
So where familiarity is based on something that happens after the arrest, forget about whether it's an officer or not, would there be a problem with a rule requiring the witness to identify specific features of the defendant that are distinctive and point to the places on the video where you can see those?
No, I don't know that that's a rule that would not make sense. What I would say, though, for this particular case is that if the officer is going to, if the officer is going to rely on identifying body type or gait, those are things that are going to be relatively apparent from watching the video. And certainly the
Right,
jury
but
can
wouldn't-
observe.
but my point is, wouldn't the officer have to say that the thing that is distinctive about this person's gait is that he lists to the left when he walks, or his left foot, something that you can see on the tape and could be pointed out to the jury so they could observe whether the characteristic the officer says this person has, based on the observations that happened after the crime, are something that can be seen on the tape.
It probably would be helpful to do that. However, it's somewhat hollow because I'm not sure the jury is going to be in a position to really observe gait of the defendant live to compare. I mean, my point being that a witness could simply describe whatever they see on the video and say, "Up, I've met my, I've now provided the basis," and there's not really a way to test that. And that, is conceivably problematic. But I'm not sure that is I'm not sure it should be a stricter.
It would take care of the nose question here, for example.
It would. I mean, I think the record speaks on its own that that's not going to be a valid basis. I'm assuming no juror would have looked at that and said, "Oh, yeah, definitely," because they watched the video themselves. But that's where I would be troubled by a rule saying you must set out certain bases or a certain number of observations, because if it's gait, it should be relatively self-evident from the video in this case.
Well, he was running in the video, right, for the most part, so he was
There are-
running
there-
in the officer's presence, arguably, and there
Sure.
were just maybe a couple of seconds, maybe, when he walked before
There
the-
was a brief number of seconds when he walks at the top of the frame, and then he does run back through the parking
So how
lot.
does that distinguish his gait? Is it a distinguishable gait here?
There are factors that I can see that I would argue are noticeably different than the 3 or 4 other people that were sort of right behind him when he's walking out of the frame. We don't really see anybody running to compare, but he did have a certain style to his run with holding the weapon out with his one hand and his arm kind of
But he didn't
flailing
run in the
about.
presence of the officer and the detectives, right? So
Not
how
that
do
we
you
know from the
compare,
record.
like, how he ran? He never saw him run.
No, but the officer did say that he had walked with him, and then the walk is, I think, visible on the video.
But is the point of specificity to be able to compare the characteristic with the defendant, him or herself, or is it to provide some basis for evaluating how reliable the, officer's identification is? In other words, you could say, I've walked with him X times and he limps on his left leg, right? And the video shows the same.
It probably serves a different purpose depending on whether we're in the voir dire sort of hearing portion of the proceedings versus the live jury testimony. The initial being the sort of minimum level that the trial court's going to need to see to permit the testimony, and then the portion in front of the jury is going to be expressly to allow the jury itself to evaluate and make that decision. And my position here is that there is a record basis that the court not only conducted sort of that two-step inquiry, but that the trial court properly permitted that testimony, and there was enough there, based on the video, for the jury to find the detective's identification testimony credible.
What about the judge's instruction or lack thereof? Because, again, it's a close case, right? It's an identification case, and you only have the opinion of someone who did not witness the event,
Yes.
right?
So
So you don't have any kind of limiting instruction. You have something about Molyneux, don't infer anything by the fact that they knew each other or that the detective knew him. But there's nothing there, I understand that it wasn't requested, but also there's nothing in the final charge. So how is the jury to have some guidance in evaluating, in this case, how to consider this particular opinion?
absolutely. I would point the court to the 7 pages of jury instructions that I see as relevant, and obviously acknowledging that there was no lay opinion, lay identification opinion charge requested or given. But the court explained, and this is obviously just part of the normal instructions, but the court explained that the jury can evaluate the officer's testimony or this evidence on whether the officer saw the events, whether his testimony was plausible. And I think that maybe speaks to the nose example. I'm not sure a juror would agree that that was a really plausible way to identify the defendant. But then also bias, motive to lie. Does the officer have an interest in the outcome? In terms of whether an ID was mistaken, did the officer have the capacity to observe and remember features? Did he have a reason to do that? Lighting, distance involved in the identification. Was he there live or not? There was a sort of breadth of instructions provided just as part of the normal charge that we can assume the jury heard those and took those into account in terms of evaluating the detective's testimony. Given that trial courts are granted the discretion to charge the jury in a way that is appropriate, while I would agree that I would have liked to have seen a more tailored charge with respect to the detective's testimony here, the record is not devoid of instructions that apply here or that would have safeguarded against the jury just kind of being taken along for the ride, so to speak.
Thank you.
Thank you.
One thing I have to mention, Your Honors, there's been a lot of talk about the gait of Mr. Mosley, and please don't take my word for this, but there is no mention of his gait anywhere in the record. Detective Kilburn says, in the voir dire, he says, the only thing that can relate to his walking at all is that he walks side by side with him, okay? That's the only thing he says in the voir dire. In the actual trial testimony in front of the jury, he says that he walked with him before. He says he was familiar with his body type and familiar with his build. And he never says, the only thing he says that he based his identification in the video on is, he's asked the question, and he says, based on my interactions with him and viewing the video, based on his build and the shape of his nose. So those are the only two things that he says, his build and his nose, the only two things in the record that he says he identified him on. So I think in a different case, the gait could be an interesting question. I don't think it's a question that's relevant in this case. And even if he did talk about his gait, if you look at the frame rate on this video, if you look at the choppiness of it, you can't glean a lot about this defendant's movements from that. But I did want to make that clear and obviously check my work. The only other thing I wanted to mention briefly is a policy point about post-crime, post-arrest familiarity by law enforcement. And I think that's something that this court should think about very carefully. And the reason they should is because you don't want to get into a situation where on any blurry video case, you can have law enforcement do an interview post-arrest with this defendant, possibly cynically, possibly not, but for the sole purpose of having him be an identification witness on that case.
But you don't have any categorical objection, do you? Correct me if you do, to having a non-precipient witness provide some testimony on a video if a foundation is laid?
If the foundation is laid and it's something that the jury, that will truly assist the jury that they can't observe on their own, and there's a nexus to the video in the way we talked about.
Right. And that could, in some circumstance, I take it you acknowledge, be a law enforcement officer, but you're identifying particular concerns that might be attendant to that. Is that?
Yes, I am. And I'm also, if I can just raise the bigger point, that this should be, the lay identification testimony, opinion testimony should be an exception. And we're having a situation where the exception is swallowing the rule here, and it certainly threatens to increase. So, and the law enforcement aspect is another reason for us to be very wary of it.
Thank you.
Thank you, Your Honors.